Hello. Okay. Hello, everyone, and welcome to another exciting live stream with immigrationquestion.com. Today, we are diving into a journey many might find familiar or aspire to take, transitioning from an H-1B visa to permanent residency, a green card. My name is Maliha, and I'll be your host for today's session. Before we get right into it, let's set the stage. Many people have worked tirelessly in the tech industry, building their careers in the United States on an H-1B visa. The opportunities for them are boundless, but so are the uncertainties. A vital question many ask is centered around how can they secure a long-term future in the United States. Our topic today is from H-1B to green card, long-term immigration planning for tech professionals. This was curated to guide us in creating a roadmap to transiting from a temporary visa to green card, and that story we're unpacking today. By the end of today's session, you'll walk away with a clear plan for your immigration journey. To guide us through, today is member of the American Immigration Lawyers Association and the California State Bar. Our guest speaker is an associate immigration attorney with extensive experience in handling cases such as E2, H-1B, L-1A, L-1B, EB-1C, PERM, and asylum proceedings, among others in Los Angeles and Van Nuys immigration courts. Join me, welcome attorney Yualine Ures Contreras. You're very welcome, attorney Contreras. We are glad to have you on the show.
Thank you, Meliha. I'm happy to be here today.
It's an honor, attorney Contreras. To our audience streaming on various online platforms, as always, it's about to get exciting, so grab your pens and notepads as we begin. Now that we've set the stage, let's dive right in. Let's start with the basics, Attorney Contreras. For our viewers, who may not be familiar what is the H-1B visa and when it comes to transitioning, what are the main steps involved moving from H-1B visa to a green card?
Okay, thank you, Meliha, for the first question. To kind of explain a little bit about the H-1B and then, the transition into the perm, just for some of the viewers, if you don't know what H-1B is, H-1B basically is a non-immigrant work visa for specialty occupation positions. What this means is basically some positions, basically, for example, if we're talking about software people, software developers, right? Normally for a position as that, the occupational handbook, which is a very specific thing, USCIS, which is Immigration Services, looks for the H-1B, is that a bachelor's is a minimum of a requirement for that position, basically. So certain occupations basically would qualify for the H-1B. One thing to consider for the H-1B is there's two ways to go through the H-1B. One is if you're go through it's really considered the lottery. That's how a lot of people consider it. Basically, every March through April at some point, a USCIS does a basically registration period, and then you submit if you've never had an H-1B cap before to get an H-1B cap, and then get filed by a U.S. company to get an H-1B visa. However, there's an exception to that cap lottery, which is if you have a cap exempt employer. So certain nonprofits, research institutions, higher education institutions, you don't have to go through the cap lotteries, but the specialty occupation is still a requirement for both options basically. Now, if you have somebody that's already on H-1B and now they're looking about the transition period into perm, so perm basically is the labor certification process, which basically means that an employer, U.S. employer, wants to sponsor a person, foreign worker, for green card based on employment based. And the thing to consider is basically there's different categories, and we're going to get into detail into later on. Basically, what you have to consider is whatever position that you're going to be doing for perm. Is it related to the current position? Do you have work experience? These are all things you would discuss with your potential perm sponsor to see which position they are willing to offer. Do they have the qualifications? So all that would be necessary in regards to that. But one of the good things is being on H-1B to perm is basically that for the most part you have that education aspect of it. So if it's a really professional position, you have the education most likely than not. If you don't, because that's a different discussion specifically per case, but it's a good thing for H-1B, and perm tends to go along really well for that process.
Thank you so much, Attorney Contreras. That was quite insightful. Perm labor certification, as you said, is a term that is found intimidating. Can you explain what it is, why it's essential, and how it impacts the green card application process?
Okay, so thank you, Belia, for that question. So, I'll break down perm as much as I can. It's very detailed, and you could go into a whole conversation with that. But to kind of give the building blocks of what a perm labor certification is basically saying is, there's two ways to get a green card in the U.S. One through family based, one through employment based, right? If you go through the perm labor certification, basically a U.S. employer is saying to the U.S. government, specifically immigration services, I want to hire a foreign worker. I have tried to, look for U.S. employees. They're not available. This is the position I want to sponsor them for, basically. And at that point, they do the process initially with the Department of Labor, U.S. Department of Labor, to do a prevailing wage. That's the first part that we do with the U.S. company. That's basically the wage that the U.S. company will need to pay the foreign worker getting petitioned for this process once they get their green card based on their category. So that's the very first step. That could take a few months. And then you move on basically then to the recruitment process, which is what I mentioned earlier, basically saying, there is no U.S. employee available. We posted in different avenues. They are not available. And that has to go through a few months as well. And then after that, then you're officially able to file the perm application, which is literally the labor certification that verifies that all the previous two steps have taken place. And then you move on basically to wait for the perm labor certification. And then you move on officially with immigration services to file your category for potential future green card, which is either, for example, EB2, EB3, which is through labor certification, one of the most common ones. And then you're able to then file a green card, but that is also subject to specific steps in regards to what your country of origin is as well. So that's another thing to consider for the impacts of your green card, which is, once you go through all the labor certification, then when you get through the first step with USCIS, which is the I-140, which gives you the category, either EB2 or EB3, then whether you're able to file a green card depends on where you're from, born, not just where you have a citizenship, but where you were born, basically. Because some countries, for example, China, India, there is a little bit of a delay of availability for green cards based on your EB2 or EB3 category. So that's really something to consider when you're looking to do the perm certification process with an employer, U.S. company, which is which category you are going to decide, because that does have an effect on when you could apply your green card in the future, basically.
That's quite interesting. Thank you so much for the insight, Attorney Contreras. Now let's talk about the green card categories that you mentioned. For tech professionals specifically, what are the key differences between the EB2 and EB3 categories, and how does one determine the best fit?
Yeah, so in regards to that specific point, which I just was briefly touching, and I'm happy to go more in detail with it. The EB2 most commonly is it has to be an advanced profession basically So most commonly is a profession that would require the requirements of either a master's, a U.S. master's, or equivalency of a U.S. master's, basically. So maybe you didn't do your master's here, but you did your master's abroad, and you able to get it equivalency, and it still counts as a U.S. equivalency here. So that's one way, master's. And then the other one is if you don't have a master's, but you have an equivalency of a bachelor's and 5 years of progressive work experience, then that could qualify for EB2. So those are the two most common ones I see. Then for EB3, if you don't have either an advanced degree or advanced for the EB2 category or the Bachelor of 5, then you would be looking at EB3, which is basically it's still either professional, skilled, or unskilled occupations. So this could either be, for example, bachelor's plus two requirements, or bachelor's in no experience, or high school. And then the unskilled is in the EB3 as well. So somebody that doesn't require any education and just some experience or no experience. So it's kind of a lump category for EB3. Most commonly, EB2 is a little bit more professional, basically. And then the key difference, really, one of the biggest things for EB2 and EB3 to consider is a few things, basically, right? As I mentioned, the perm, the EB3, EB2, something to consider basically for labor certification specifically is what is the position, what are the requirements, the wage is set. So it's something to also discuss with the U.S. company, because it is U.S. company dependent, this process, the petitioner basically, for wage. But another thing to consider, and it's more concerning really the beneficiary, the person that's going to get the green card, is, if you do an EB3, like I mentioned earlier, if you're from country of origin that's a little bit delayed, you might have to wait a little bit longer than EB2. Sometimes there's not much of a difference, sometimes there is. So I think that's the biggest question I usually get, which is which one is it best? Well, it depends on what the company is looking for, right? The position of the requirements. And that kind of, then ties into what the EB2 or EB3 category will fit. Something I kind of want to briefly mention so that our viewers don't get a little confused, because I know we're concentrating on perm labor certification. For EB2, there is a category for under it, which is the national interest waiver for EB2, which bypasses the labor certification. That's a little bit different, but it's an addition to EB2, which we're not going to touch base a lot of it. But there is another category under EB2 as well. But just want to mention that.
Absolutely, that was quite interesting. Thank you so much for that, Attorney Contreras. Let's address some concerns, some common concerns. Visa backlogs are one of them. How should tech professionals handle delays, and what strategies can they employ to maintain job portability?
Okay. So basically, the one thing that I want to mention, because that's a very common question, a lot of the individuals I work with are predominantly from countries that do have a visa delay, basically for green card. So one of the benefits in 2000 was that there was a government basically law that went through that initiates that basically if you have two parts, which is if you have an I-140, which is basically your employer or your company that's sponsoring you already did the labor certification, got it certified, and then if you have an I-140 that's been approved, and the green card is not available to file, you could continue extending your H-1B beyond 6 years. So 6 years is a maximum for an H-1B. So if you're getting near and you have the I-140 approved, you could continuing to extend your H-1B beyond the 6 years until the green card number basically becomes available for you to file. So that's one thing. So another thing is, what if you already got the perm certification process approved, you got the I-140 approved, and you actually are able to file your 485, but it's been pending for a while, because sometimes it takes a while to get approved. If after 6 years, I'm sorry, not 6 years, 6 months, sorry, it's been pending, the 45, the green card application has been pending. And if you need to, change employers for some reason, or something happens, in regards to that you need to move from the position, there is a possibility to do, it's called an AC-21, under AC-21, to port basically your process to another employer. It's very specific though. So this is very case to case specific. But one of the opportunities is this: if it's in the same position, if your application has been pending, it's very specific, 180 days or more. And there's some other requirements, but there is a possibility that even though if you've gone through the whole process to port to another employer, that's not the same one that sponsored you. But again, it's very case by case specific. There is just other options if for some reason, you're at that situation.
Thank you so much, Attorney Contreras, for your time so far and this deep conversation. And thank you for joining us. For the audience, thank you for tuning in from different social media platforms. We have the honor of being joined today by the very attorney Contreras, a seasoned associate immigration attorney who has done an amazing job with today's topic. This is immigrationquestion.com, a platform designed to make every immigrant's journey in the United States easier. Ask your immigration questions for free in any language, and you will be connected to a verified attorney who can help you with legal guidance. Even better, you may secure yourself a discreet and a free initial consultation with an immigration attorney. Head to www.immigrationquestion.com and sign up today. Before we get into the live question and answer, Attorney Contreras, let's talk about other challenges like changing employers or roles during the green card process. How can professionals navigate these scenarios without jeopardizing their application?
So it's kind of similar to the previous question, Maliha. So basically, it just depends where the process is, basically. So, like I mentioned earlier, if you are at the I-140 and you're still waiting for the green card,
Mhm,
you can actually, and I could add this in, it wasn't mentioned previously. If you
mhm,
have an I-140, it has been filed already, it's been
mhm,
more than 6 months, you are able to retain that priority date. So once you
mhm,
file your labor certification, you get a priority date. And that
mhm,
really is a date that's really important for your green card process. Basically, you can
mhm,
use that to then move on to another employer and keep extending your H-1B. The only thing is the labor certification will need to be redone with that new employer, right? Or you could go back to that previous if that position is still
mhm,
available, basically. But that's one of the benefits, right? The other thing is then if they've already done the I-140 and they've already filed the green card, then it's kind of similar to my previous answer, which is basically it just depends how long has the adjustment application been pending, the green card application been pending, if it's been 100 and more, 180 days or more, and then is the position being offered in the same, same occupation. So those are things that would need to be considered. They're, like I mentioned, case by case, but there are options that, I discuss very frequently with, clients if they have
mhm,
questions such as these. But
mhm.
there are options. That's the biggest thing.
Absolutely. Thank you so much for the insightful conversation. This has been such an insightful conversation indeed. To our audience, the floor is now open for question and answers. Please feel free to type your questions into the chat box, and we'll try to address as many as possible. If you want to call us live and ask your questions directly, the number to dial is 516-703-3483. So let's have the live questions going. We have very first question from Divinia. My H-1B will expire soon. I have to apply for green card, but it's not ready yet. Can I still stay in the United States?
Hi, thank you, Davina, for that question. So, in regards to your under, so this is something that each person needs to know basically. For any kind of, for the PAM labor certification, or if you're going to file for a green card, you always have to make sure that you maintain your underlying status. So that be if you're on an H-1B, if you're on an L-1, whatever the visa is, you have to maintain until the 45 application is actually filed, right? Because at that point, then you're kind of in a pending 485 status, right? And usually it's always recommended that you maintain any underlying status until your 45 is approved, right? Because an interview could come in, that could happen. It's not always, but that could always be the case. But for you specifically, I would need to know more about how much H-1B is pending so that we could do a calculation on what the best options are. And then the green card, it would depend if we're discussing I-140 or are we discussing actually 45. So that's another consideration because as I mentioned earlier, if you have an H-1B and you have an I-140 approved and then you're 40 and you're from a country of origin that has a backlog basically, you could keep extending your H-1B. So it just depends. I think the question I would need a little bit more detail to see if you have other options specifically.
Absolutely. Thank you. Thank you so much for the valuable insight, Attorney Contreras. Moving on to our next question from Cabello. If I lose my job while I'm on H-1B, how much time do I have to get a new job before I will have to leave the country?
So there is a grace period if for some reason you lose your job. And so basically during that grace period is when you need to make sure that you basically find a new sponsor for H-1B. If during that grace period, you don't find basically an employer, then the good thing is not, I know it's not the best situation, but you still are able to reuse or use the leftover H-1B if you're not able to get an employer with that within that time of grace period. But it would have to be a consular process H-1B, and then you would have to do the process of visa stamping at the consulate in your consulate of home country, basically U.S. consulate in the home country. But it just depends. It would have to be within the period of the grace period.
That was a quite insightful, Attorney Contreras. Moving on to our next question from the dial. Can I start my own business on H-1B visa as I wait for a green card?
So there is an H-1B entrepreneur option. It is an option. The only thing to consider that for entrepreneur, there are a little bit different requirements into because one of the things that employer-employee relationship, it's basically for H-1B, you could also do concurrent filings as well. So there it is an option. The one thing to consider though, I don't know if the waiting period for the green card is with another sponsor. The only thing is green card can't be done through your own business for perm. So you just kind of want to make sure you kind of discuss what your strategy is once you do your H-1B through your sole company, what the options are, because it's a little bit different for a green card if you're doing it through labor certification. If you have a green card through a self petition process, then that wouldn't be as much of a worry. It's just it depends what the H-1B, sorry, what the green card was filed as. But H-1B entrepreneur is an option.
That's something that I didn't know also. That's quite insightful. Thank you so much, Attorney Contreras. Moving on to our next question by Dioff. Can I apply for a green card while I'm still on STEM OPT or do I have to get H-1B first?
No, you don't have to get an H-1B first. I mean, I've had clients where they go from STEM to another visa type and then they do green card. So as long as you fulfill the requirements for any visa category that you have, the only thing, as I mentioned earlier, is that if you are on a certain status, you want to maintain that status until the green card gets filed. And even my recommendation is even after it's pending, you should still maintain it. But it doesn't have to be that, you know, it's just the processing time usually for green cards. If you're doing perm, if we're talking perm specifically, it is a long time. So unless you have STEM for a long time, which usually it's, 1 plus 2 is 3. So if you're able to do the labor certification process during the STEM OPT, you could do the green card process. You don't need to do H-1B.
Thank you so much for the insight, Attorney Contreras. Moving on to our next question from Salman. I am a software engineer from India. How long will it take for me to get a green card?
Oh, that's a great question, but it's a case by case. I'll say this the reason why. The norm, if we're talking processing times today, I'll give you an example of today, right? Right now, the labor certification process is taking anywhere between, want to say 2 years maybe, because we're talking about 5 to 6 months for the first part. We're talking 2 months around for the second part, so we're 7, and we're talking about 14 days for the labor certification. So if we're lucky, a year and a half, 2 years, and then you file the I-140, which is to get your EB2 or EB3 category. And then when that is filed, the good thing is there is premium processing, so you could get a decision within 15 business days. But at that point, because you are from India, and as I mentioned earlier, India is one of the country of origins that have a little bit of a delay for EB2 or EB3. Then at that point, we would be looking at, about a 10-year wait to be able to file your green card if we're talking EB2 or EB3, right? So that could be putting you at like 12 years at this point because you're not processing that soon. Now, the good thing is, for example, if you are able to fulfill categories for EB1, uh, EB1 basically, there is a little bit of a faster route for that, but of course you have to fulfill those requirements for EB1. So it could either be EB1A, EB1B, or EB1C. So those are options as well. But if we're talking labor certification as of today's point, it would be a long wait unless you're able to fulfill other categories, basically.
Thank you so much for the valuable insight, Attorney Contreras. Moving on to our next question from Chloe. If I do not get H-1B visa, is there another type of visa for tech professionals?
Yeah, I mean, very common. I get this question because I work with a lot of tech professionals. So there is, for example, O1. So if you're really important in the tech industry, and it doesn't have to be just top tier, 1%, maybe you've worked in important projects for important companies. That would be potentially an O1A. If there's other requirements, but that could be something I would usually look into with a tech professional. Also, if you're a tech professional and you work with a company either abroad or in the past, and they have a related company in the US, and you've been in an occupation at a management level, managing staff, or if you had a very specialized position with specialized expertise, that could be potentially an L1, A or B. So there are other options. Also, if you are trying to open your own business. Certain countries have options in regarding to running your own business and starting your own business here in the U.S. They have treaties basically with countries of certain countries in the U.S. So there's other options. It doesn't just because you're tech doesn't mean H-1B. I think that's a lot of the view out there that because if you're tech it has to be H-1B, but there are other options out there. I would just need to discuss it with whoever wants to know that to see what are the options out there. But there are other options.
Thank you so much. That was a quite great insight, Attorney Contreras. While we like to continue, we have to bring this session to an end. This was our last question. Thank you so much for joining us. A special thank you to our guest speaker for sharing her time and expertise. We look forward to having you back on the show.
Thank you, Maliha, and thank you, Immigration Questions. I'm happy to be here.
It was an honor having you here. Miss. We hope this webinar answered some of your pressing questions on moving from H-1B to Green Card, long-term immigration planning for tech professionals. Visit our website at immigrationquestion.com to connect with experienced immigration attorneys who can guide you through your unique situation. If you missed any part of this session or would love to listen again, this live stream is being recorded and will be available for listening on Spotify. Simply search Borderless Talk by immigrationquestion.com and listen to today's session and previous ones on the go. See you at our next session at the same time, same platforms. You don't want to miss the next session, so make it to date with us. Once again, thank you for being on the session, Attorney Contreras. It was indeed an insightful session. All thanks to you. We look forward to having you again.
Thank you.
Thank you. Have a great noon, everyone. See you next week. Stay informed and stay empowered.